The Supreme Court of India on Tuesday delivered its much-awaited order on the legality of marriage for same-sex couples. A five-judge bench headed by Chief Justice of India D.Y. Chandrachud heard these arguments in the cases between April and May this year and pronounced its verdict today. The bench noted that there were degrees of agreement and disagreement on how far the court could go to grant the right of marriage to the members of the LGBTQIA+ community. Four judgments were delivered, one each by Chief Justice and Justices S.K. Kaul, S.R. Bhat and P.S. Narasimha. Here are the key points from the order. The Supreme Court refuses to recognize same-sex marriage and says it is for the legislature to do so. Homosexuality or queerness is not an urban concept or restricted to the upper class of the society. Queerness can be regardless of one's caste or class or socio-economic status, said the CJI. The CJI also asserted that the top court cannot compel parliament or state assemblies to create a new institution of marriage. It also cannot hold Special Marriage Act unconstitutional just because it doesn't recognize same-sex marriages. The Supreme Court refused to strike down Special Marriage Act and Foreign Marriage Act for not recognizing queer marriages. The CJI stated, whether a change in the regime of Special Marriage Act is required is for the Parliament to decide. This court must be careful to not enter into the legislative domain. The CJI also said that if two transgender persons intend to marry, identify themselves as a trans man and a trans woman, their marriage can be registered under the Special Marriage Act. He also said that all LGBTQIA+ couples identifying themselves as a man or a woman can also marry. Ability to choose life partner goes to the root of right of life and liberty under Article 21, said the CJI. The top court struck down the CARA regulation restricting queer and unmarried couples from adoption. He clarified that his judgment has not granted any social or legal status or legal recognition to same-sex marriages but has ensured that certain legitimate benefits flow to queer couples. The CJI accepted S.G. Tushar Mehta's proposal on behalf of the Centre for setting up an expert panel headed by the Cabinet Secretary to consider granting queer couples a bouquet of rights and privileges except the right to marriage that are available to heterosexual couples. Justice S.K. Kaul agrees with the CJI's views. He says that the state must ensure that queer couples face no discrimination in accessing basic needs and societal tolerance. He also said that giving right of marriage to queer couples by the court was not possible as it is a legislative exercise. Justice S.K. Kaul also said that non-heterosexual and heterosexual unions must be seen as both sides of the same coin. Kaul also added that legal recognition of non-heterosexual unions is a step towards marriage equality. There is a need for an anti-discrimination law. Justice S.K. Kaul says, after all, it's my life, as said in the song by Bon Jovi. Justice Bhat's verdict. Justice S.R. Bhat, who will retire on October 20, in his judgment agreed with the CJI and Justice Kaul that there is no fundamental right to marry guaranteed by the Constitution, though queer couples have a right to live together unhindered and undisturbed. Justice Bhat also disagreed with the CJI for right to adoption for queer couples. Justice Hema Kohli's verdict. Justice Hema Kohli agrees with Justice Bhat. Justice P.S. Narasimha in his opinion said that the right to marry is not a fundamental right. Hence it cannot be claimed as a matter of right for the LGBTQIA+ community. Thus the five-judge bench unanimously refused to grant marriage rights to queer couples in India.
Stay with the Times of India for news breaks, analysis, interviews and events. We bring you stories from your neighborhood and from across the globe as well. Subscribe to our YouTube channel. Hit the like button and press the bell icon so you don't miss any of our videos.